This is a tort law lecture. The second one is on specific business torts. And we will talk about some, not all, of the business torts. For example, we're not going to talk about infringement on intellectual property rights. That's for the intellectual property rights lecture, and the antitrust violations that will be covered in the antitrust lecture. So what we're going to focus on is defamation, tortious interference with contractual relations, tortious interference with prospective business advantage, aka tortious interference with business conduct, fraud, and invasion of privacy. First, defamation. Defamation is the publication of an untruthful statement of fact that damages the reputation of the plaintiff. You have to recognize the fact that, you have to recognize that opinion is not fact. Opinion is something that cannot be proven one way or the other. Fact is a statement that can be proven one way or the other. Historically, there have been two types of defamation. We classify them as slander, which is spoken, or libel. Note the spelling of libel, L-I-B-E-L, which is written or in some fixed medium. Obviously, over the centuries, we've developed other types of fixed medium. Historically, all you had was the written page, plus the spoken word. The intent to injure is not required, meaning you can negligently damage somebody's reputation with a statement. Now, usually we think of the intent to make the statement. But in this, for example, in this case, Dun & Bradstreet, Inc. versus Green Moss Builders, which was a Supreme Court case from 1985, a private individual was defamed by an erroneous Dun & Bradstreet credit report. Now, you recognize the name Dun & Bradstreet as one of the premier business credit reporting agencies. The trial court awarded compensatory and punitive damages without showing of malice, and then the court looked at the value of the speech, meaning the credit report, not of the type given a high priority of protection, but it was held that the plaintiff was entitled to presumed or punitive damages without malice. I have had one situation where a consumer credit report, I think it was Equifax, had a credit report that contained the fact that my cousin was bankrupt, and I knew at the time that he had never been bankrupt, that he was always religiously paying his bills, and he was borrowing money from the bank, and he wasn't aware of it, and they told him. And this was 97, 98 or so. And so I wrote a letter to the attorney to Equifax, and I told them that we would sue them under the Fair Credit Reporting Act if this wasn't taken care of. I immediately got a phone call from their attorney apologizing for the incident and asking what could be done. And as I was not interested in filing the suit, I demanded that they immediately repair the credit report and send my cousin a letter of apology, and that we would let it go, and they did that. Obviously, it was the fear of action. Now, for defamation, we we run up against the First Amendment rights. And this is especially the case involving media. The media has certain constitutional protections. So if the media, newspaper, television, magazine, whatever, writes an article about someone and that article contains an untrue statement that may damage the reputation of that individual, then if a court gives sanctions against the agency, then it would be a chilling effect because of the government action against it. So the United States Supreme Court in the 60s established a constitutional test. I think this is Sullivan versus Firestone versus Time Inc., I think, the magazine. Ms. Sullivan was a socialite, heiress, and magazine had written, or New York Times rather, Sullivan versus New York Times, or Firestone versus New York Times, one of those. And they'd written something untruthful about it. And the court established a constitutional test saying if a public person is defamed, then the public person is required to prove that the defendant who published a statement acted with actual malice. It means you know or should have known that injury would result. Now, a private person does not have to prove actual malice. All a private person has to prove is that an untruthful statement was published, meaning it was told to some third party, and that untruthful statement damaged the reputation of the plaintiff. There are certain defenses, legal defenses to defamation. Truth is always a defense. Sometimes the truth hurts, but it's a defense. There's an absolute privilege. For example, politicians and judges have the absolute privilege where they can't be prosecuted for saying something erroneous, untruthful. Attorneys in legal proceedings, the same way. There's a qualified privilege, and this qualified privilege is particularly important for business because it gives business a legal defense to defamation and reduces some of the risk to businesses. A qualified privilege, and this is also it's provided by, issued by the Tennessee Supreme Court in the case of Hargrove versus Long, and other states have it as well. Extends to all communications made in good faith, so underscore in good faith, upon any subject matter in which the party communicating has an interest or duty, meaning there is a need to know, right? A need to convey this communication, or to which he has a duty to a person having a corresponding duty or interest. For example, some former employers are required to provide information on former employees. It's dealing within medicine or within schools, daycares, etc. National defense or security. In the Tennessee Supreme Court case of Hargrove versus Long, and by the way, there's an excellent article on defamation of employers in the Tennessee Bar Association, and an article in the Tennessee Bar Association journal, its own Moodle rooms, that discusses Hargrove versus Long and the qualified privilege. The court said that statement that a former employee was ineligible for rehire and totally incompetent when asked by a prospective employer was entitled to a qualified privilege. Held that one who in the regular course of business is asked by a prospective employer or a potential creditor for information concerning a person is entitled to the defense of qualified privilege if the statement would have been otherwise regarded as defamatory, unless the statement was made with knowing falsity, in bad faith, or with reckless disregard of the truth. There's your bad faith right there. If you know that it's false, it's in bad faith. If it's actually made in bad faith, or with reckless disregard of the truth, you don't care, if it's true or not true. You make the statement. All right? So there has to be this relationship, this need to know. All right, Blatnick versus Avery Dennison. This is one of our featured cases, and it provides a spin. It's a case involving qualified privilege and defamation. Now, employers can rely on a qualified privilege. The problem is that employers should not take the risk of a defamation lawsuit. Keep in mind, if a statement is made, if a statement is made about an individual, it should be proven as a fact. All right? And so the typical type of prospective employer gives a phone call or sends a letter asking for a recommendation or information on a former employee. Should the former employer requesting from which the information is requested, should that person provide the information? So the situation is this: do you want to take a chance of a defamation lawsuit? You don't buy a lawsuit. And so the easiest thing to do is simply say, I'm not going to provide that information as a matter of policy. I will tell you that the person did work for us, that the person worked for this period, and that this was the person's job or title or position. Nothing else, nothing about the quality of the work. Now, keep in mind that in very limited situations, there is a legal duty to provide that information. But that usually falls on children or the affirmed, or in national security or defense matters. Could an employer provide the information? The answer is yes. The employer could. But the employer may face a defamation lawsuit and then have to rely on the qualified privilege. Using the qualified privilege is only a defense, however. So what can an employer do? Well, an employer should have a good reference policy. And that good reference policy should limit the number of persons who can respond to a reference request. Loose lips sink ships. If too many people can make statements, then there is less control over what is being said. Second thing that can do, and it's a matter of good policy, is employee releases. A prospective employer who needs to do a background check on a prospective employee or an applicant can request the employee to sign a release and a waiver of liability for the prospective employer and any former employers to which request for information is given. Now, that will not, that release and release of liability, waiver of liability, will not work toward intentional misstatements of fact or anything worse than negligence. It'll protect against negligence, but nothing worse than that. Gross negligence, recklessness, or willful or wanton disclosure. But at least reduces the risk. Reduces the risk of a defamation lawsuit. Second area of tort is tortious interference with contractual relations. A person cannot knowingly induce another person to knowingly induce another to breach a contract with someone else unless it's done with privilege or is justified. What we have in this tort is the plaintiff is under a contract with someone else, and the defendant induces or offers some incentive for the other contracting party who is under the contract with the plaintiff to breach that contract. Maybe they give more money. Maybe they make them a better offer. And in that particular case, the plaintiff, the person that's been injured, can sue for breach of contract to the party that does not that reneges on the contract. They can sue. That's breach of contract, but the person inducing the breach can be a defendant in a tort lawsuit. And because this is an intentional tort, it may give rise to punitive damages, when generally breach of contract does not give rise to punitive damages. An example of this may be the rating of employees under a contract. Memphis in the early 70s, 73, 74, maybe 74, 75, had a professional football team. They were called the Memphis Southmen, or the Memphis Grizzlies, actually, but Southmen. And it was part of the World Football League, an upstart professional football league that was played during the summer. And this was the league that was 10 years before the United States Football League, which was 15 years before, or 20 years before the XFL. The Memphis team had some talent on it. In fact, they entered into contracts with 3 of the best players on the Miami Dolphins football team, and the Miami Dolphins were Super Bowl champs. Only Bob Greasy remained with them. Zonka, Kick, and Warfield, all 3 jumped ship from the Miami Dolphins, the world champs, to the Memphis Southmen in the World Football League. Now, the owners of the World Football League sent a letter to all of the NFL players and telling them about the World Football League, and they said, when your playing time is up, when your contracts are up with your National Football League team, we would like we would like to talk to you about playing for us. We think you can make more money with us, and you'll do better. You'll do better financially. And of course, some of the players did that. So the National Football League sued the World Football League under the tort for tortious interference with contractual relations. But the court held for the World Football League because the World Football League was not inducing them to breach the contract. And tortious interference with contract requires an induced breach. The letter of interest simply says when your contract has expired. Another example is Pennzoil versus Texaco, which we talked about from the standpoint of procedure earlier. Managers have a privilege, however. General counsel has a privilege. Financial advisors have a privilege. And remember that privilege and justification are two defenses to the tort of interference with contractual relations. In Los Angeles Airways Inc. versus Davis, Davis is the defendant being sued by the Los Angeles Airways under this tort. Los Angeles Airways has a contract with, I believe, Summa Corporation. And Summa Corporation was part of Hughes Corporation, Howard Hughes's old firm. And Davis was general counsel for Hughes Tool, and Davis was competing for the CEO's position with a person named Mayhew, and so it was a matter of who could produce the most, who had the most feathers in his cap, who could get one over on the next one. So Davis knew that Los Angeles Airways, small airline, it had some assets, and he knew that they were financially on the brink, and that the only thing keeping them from going under was the contract that they had with Summa. Now Davis wanted Summa to, and he wanted the company to acquire the assets of L.A. Airways. They didn't want management, didn't want goodwill or anything, just wanted assets. So Davis advised a plan and had advised the company to intentionally breach its contract with L.A. Airways. The idea was you breach the contract, you throw them into insolvency. Once they became insolvent, you buy the assets dirt cheap in bankruptcy. I mean, it's a remarkable strategy. Love the strategy. The ethics of it leaves a lot to be desired, but the strategy is great. And it all happened. Worked just as Davis had planned, just as general counsel planned. L.A. Airways then sues Davis. Now keep in mind, if you're under a contract that can be terminated with simply, usually just notice, breach of contract lawsuit doesn't mean anything at all. You can't recover very much at all. But this was a lawsuit against an executive, somebody with some money. The court held for Davis in this tortious interference with contract relations because Davis had a privilege. As general counsel, he had a privilege to advise his employer, his client, to breach the contract. Next tort, tortious interference with prospective business relations. This tort is also called tortious interference with prospective economic advantage, and also called tortious interference with business conduct. It's been around quite a bit. And in this tort, a person cannot intentionally damage the relationship with another person when done with an improper purpose or improper means. You can't damage another person's business if it's done with an improper purpose or an improper means. An example of what this may do, let's suppose you have you're a restaurant and you have a competitor across the street, and you're pretty much selling same type of product, service, same type of service, and your customers have started going, across the street. All right, how can you prevent that from happening? One way maybe will be to cause the other business to shut down. Now, how can you cause another business to shut down? The simplest way would be to hire somebody to burn the place down, right? You can't do business if you don't have a business establishment. How that would work. Another way may very well to start rumors. Get somebody to plant a bug or mouse droppings or something on the salad bar, something of this nature, right? Improper purpose or improper means. Let's take this case right here of Lowell versus Mother's Cake and Cookie Service. This is another one of those strategy type cases. Lowell operated a truck line, a small truck line. He had some assets and had a contract with Mother's Cake and Cookie Company. Now, it was a contract that was a consistent business. Lowell made most of its money from its contract with Mother's Cake and Cookie Company, but it was a contract that could be terminated without much problem by Mother's Cake and Cookie. Now, Mother's Cake and Cookie Company would like to have the assets of Lowell, but he doesn't want to buy the company, doesn't want to pay goodwill, would buy the assets real cheap. And Lowell is trying to sell the business. Now, Lowell has been shopping around. He has found a potential buyer. By the way, this is 1980s stuff, 1970s, 1980s. And Lowell has a buyer for $250,000. Now, Mother does its operation research, Mother's contacts the person who's interested in buying, and they tell them, you may buy Lowell Trucking Company, but you don't buy us. You don't get a contract with us if you buy it. Well, that scares them off, because what's the value of the company? If there are no contracts, if there's no secured service. Now, this makes Lowell Trucking Company unmarketable as an entity, and they can't sell the business. And of course, since they can't sell the business, they eventually go out of business, and they have to liquidate. And Mother's Cake and Cookie buys the assets dirt cheap in a bankruptcy. Lowell learns that Mother's had been contacting the others, and Lowell files a lawsuit for interference with business conduct. And a court held that all that's required is to damage somebody else's business with an improper purpose or an improper means. And here, it appeared that there was an improper purpose, meaning trying to run them out of business. And so the case was remanded for consideration on to make a determination as to whether or not Mother's Cake and Cookie had an improper purpose. One of the featured cases is TrawMed of America, Inc. versus Allstate Insurance Company, a case out of Memphis, in which Allstate Insurance Company damaged the plaintiff, TrawMed of America, by trying to run them out of business to prevent them from helping plaintiffs' lawyers in personal injury lawsuits against Allstate Insurance. How far does this go? Does this tort go? In Tennessee, this tort can also go to employment relationships. When there's interference, intentional interference in employment relations. An employer cannot intentionally act without privilege or justification to prevent an employee or former employee from obtaining a job with the prospective employer if this is done through lies or ill will, even if the employee is an at-will employee. An employer cannot take out its pound of flesh against a former employee. It doesn't matter that the former employee has done the employer dirty, leaving them in a lurch, for example, damaging a client. You cannot intentionally blackball or spread rumors or to contact another employer without request and give them all this dirt. All right, the tort of fraud. The fraud can be a crime or a tort. There are 5 elements to the tort of fraud. And by the way, we can also call fraud intentional misrepresentation of a fact. All right, those two were used interchangeably. The elements of a fraud that the plaintiff has to prove by a preponderance of the evidence is that the defendant made a misrepresentation of a material fact. Again, it's not opinion, right? Fact can be proven, opinion can't be proven. Puffery is not a statement of fact. And then this material fact, this misrepresentation of a material fact, must be made with intent to deceive. One of the featured cases in negligence was the case of Randy W. versus Muroc Joint School District, and that was a case of negligent misrepresentation of a material fact. In the writing of a letter of recommendation. Well, this element, with intent to deceive, this is also called scienter. It's the badness. It's the bad part of the act. Scienter. S-C-I-E-N-T-E-R. The intent to deceive. This is what makes it an intentional tort for which punitive damages may lie. The plaintiff must have relied on this misrepresentation of fact, and the plaintiff must have resulted in damage. Generally, there are 2 types of fraud. Fraud in the inducement and fraud in the execution. Fraud in the inducement is when you entice somebody to enter into a contract with you. Think of recruiting employees. The Rickert versus UPS case, for example, is such a fraud case in the hiring of airline pilots. Fraud in the execution is not so much in tort. It's more of a document type of an action where you have, through slight means, you have someone execute a negotiable instrument when they think they're signing something else. Invasion of privacy. Privacy is one of the major issues. It's been that way for 20 years. It will be that way for the next 20 years. One of the major issues in tort law. There are 4 basic types, classifications of privacy. Now, this privacy is not constitutional privacy, it's tort privacy. Remember, the Fourth Amendment will apply in a relationship between the government and the victim. But that's not the case here. True intrusion upon seclusion, misappropriation of name or likeness, or misappropriation of publicity, public disclosure of a private fact, and then the 4th type is usually a media law type case, usually just involving media, and that is false light. Just briefly on false light, this is when a media, say a newspaper or a magazine or television show, produces a story about the plaintiff, and although it's somewhat technically true, the intent is to place the plaintiff in a light that's not reality, right? It is only a perceived reality, not actual, and that misperception caused by the publication damages or injures the plaintiff. All right, let's intrusion upon seclusion is the major one, so let's just touch on these other 2 before we get into the major part. Public disclosure of a private fact. This may very well be in the HR area. There's a lot of personal information in a personnel file, private information that an employee would not want disclosed to others. For example, maybe in the HR file there is information about HIV, that the employee is HIV positive. Certainly, that's personal and that's private, and it should stay private. What if somebody in HR disclosed that? Let it get out to the other employees, such that now this employee is ostracized as a result of it. He's treated like he's not welcome anymore. That would be actionable. Misappropriation of name or likeness. This is when you use somebody's name or picture without their consent. For example, if you're putting on an advertisement and you use Peyton Manning's photograph, saying that he likes your company and so forth. Well, unless Peyton Manning has given you permission to use his photograph in your advertisement, you have misappropriated his name or likeness, and it's actionable. Misappropriation of publicity is when you disclose somebody's personal facts that they use for their public performance. The historic case here was the Great Zacchini from, I guess was the 1970s maybe. The Great Zacchini was a human cannonball. He would be, at fairs and exhibitions. He would climb into this large cannon and shoot himself out, have himself shot out of this large cannon across the arena or across the parking lot into a safety net. An amazing feat. Well, one day in Florida, a television crew saw him performing, and they televised it. And once they televised it, who the heck wanted to see it anymore? Right? So he damaged the publicity by televising his show. And he was able to maintain the lawsuit against the television station for publishing, broadcasting his show. All right. Intrusion upon seclusion. Intrusion upon... Sorry for the interruption. Intrusion upon seclusion is when the defendant unreasonably intrudes upon the plaintiff's reasonable expectation of privacy. All right, the plaintiff has a reasonable expectation of privacy, and the defendant intrudes upon that private space. It's the most widely prosecuted area of invasion of privacy. And one of the reasons why it's more likely done is because of recordings and surveillance. Employee surveillance being one of the major areas. Very important generally for employers to surveil the employees. Reasons because there is obviously management has an obligation, and that management obligation is to protect the company, to make sure the employees are productively working, they're efficient, they're doing their work well, they don't commit any unethical or criminal acts, they're not conducting business on company time, they're not committing sexual harassment, they're not infringing on other people's intellectual property or copyrights, therefore, that they are doing what they're supposed to be. They're not wasting time on the internet or on personal email, etc. Plenty of reasons to surveil employees. Plenty of methods to surveil employees. One way, simply is closed-circuit television, visually monitoring employees, checking email, checking where employees go on the internet, They can use smart badges to trace employees, RFID through those smart badges. You can use GPS technology on company vehicles, and RFID on company vehicles. You can count keystrokes to make sure data entry people are working. All of these things are common methods of surveillance. As I said, tort law differs from the Fourth Amendment rights in surveilling employees. Government employees have more rights than private employer employees. The Fourth Amendment, in the case of O'Connor versus Ortega, the Supreme Court held that a government employee has a right of privacy, and it was violated by the government when the government opened up a private file in a locked desk drawer in the employee's office. It was a reasonable expectation of privacy, and therefore the government, in order to get access to that file, and it would be the case, by the way, if it was a locked file cabinet, if it was the employee's purse, or the employee's briefcase, or employee's private computer, then the employer, as the government, would have to have a search warrant. Otherwise, it's a violation of the Fourth Amendment freedom against unreasonable searches and seizures. A private employer would generally have access to all of the furniture, all of the files in the office, unless the employer had reason to know that it was private. Reasonable expectation of privacy. Drug testing. Before we get into the right of employers to read employees' email, let's talk about drug testing, because drug testing involves privacy. Drug testing is preferred by the government, both the federal government and the state government. The federal government, as a matter of policy, encourages drug testing in order to combat improper use of drugs. And this is done through the Federal Drug-Free Workplace Act. It certainly is encouraged by workers' compensation insurers. Tennessee has a similar law, the Tennessee Drug-Free Workplace Act, and they parallel each other. And here's generally what the gist of the Drug-Free Workplace Act. Under the Drug-Free Workplace Act, the federal government encourages drug testing. And drug testing can be either of two types. One is cause-based drug testing, or suspicion-based drug testing, in which you test somebody because of you have a suspicion. And then you can also have suspicionless drug testing, in which there is no suspicion, there's no cause to test, but it's just done as a routine matter, right? Generally a random drug test. Now, under the Drug-Free Workplace Act, if there is compliance with the act, if the employer complies with the act, then the employer is given the benefit of, under workers' compensation, that if a worker is injured on the job, and if the injury was caused by, at least in part, or at least the employee was using drugs. If the employee was using drugs, then the employee's injury is not compensable under workers' compensation. Tennessee's version of it requires that the employer must prove that the use of the drug was the proximate cause of the injury to the employee. Now, part of the requirements, and this is the stiff part of the law, the drug testing system must give an employee testing positive a chance for a second drug test, a test for false positive. Sometimes errors are made in the testing process, and a test may be invalid. It may just be a bad test, may be an error made. So a test for false positive to make sure that there is no error caused by the testing company or the employer. The second one, that if an employee tests positive, the employer must not notify the police of the employee failing the test. Third, if an employee fails the test, the employer must give the employee an opportunity to go into some kind of rehabilitation program. Usually this is an unpaid rehabilitation program, non-paid time off. And if the employee agrees to that, then the employee cannot be terminated. Now that's the norm, and the benefit of it is reducing the number of workers' compensation payouts. And these are all good, and they're encouraged. Now let's look at email policies. You know that employees use the company's email system frequently for personal use. You know that employers have certain needs for monitoring email, surveilling the employers. So the issue is, when can an employer read the emails of the employee? And the general rule is that an employee's email can be read by the employer as long as the employee does not have a reasonable expectation of privacy to those emails. Now you've got a combination of two areas of law here. One is you got common law tort for invasion of privacy. And then two, you've got invasion of privacy based on federal privacy law, namely the Electronic Communications Privacy Act. Electronic Communications Privacy Act. This is also called the Federal Wiretap Statute. And the Federal Wiretap Statute makes it a crime and also gives the a private right to sue for damages when there has been a wiretap of a phone, an electronic recording of a conversation and there are some exceptions. All right, to finish up on this one, and this gives $10,000. The Electronic Communications Privacy Act gives a $10,000 damages for each illegal wiretapping. So there's an exception to the Electronic Communications Privacy Act, the wiretapping statute, and that is the business equipment exception. If the equipment belongs to the employer can monitor the telephone calls up to the point that the employer knows that the telephone call is personal. Once the employer knows that the telephone call is personal, then the employer must get off the line, can no longer monitor it. Now, an exception comes in for consent. If the party on the telephone call gives the consent, then there is a right to monitor it. Second, type of tort for invasion of privacy is the common law. And by the way, the Electronic Communications Privacy Act, for federal purposes, allows an individual to record a conversation that he or she is a party to. You can record the other side even without telling the other side that you're recording it, and that's not a violation. Some states require only one party. As long as one party is not told, that's all that's sufficient. That would be, for example, the case of Maryland, where consent is required to record any conversation. Think of Linda Tripp in the Monica Lewinsky saga. When she recorded a telephone conversation that she had with Monica Lewinsky about the blue dress, and she didn't tell Monica that she was recording the conversation. For federal purposes, it was not actionable, but for Maryland, it was actionable, and Linda Tripp was never heard from publicly again. All right. Under the Electronic Communications Privacy Act, if you are recording, and these have to be live conversations, right? Real-time conversations. If you're recording from stored services, then they're not. All right, it's not covered. All right, so let's look at email. In email, generally speaking, an employer can monitor the emails of employees if the monitoring is done from emails stored on the server. Put another way, they are not real-time monitoring. All right. So the requirements under common law invasion of privacy is the balancing act, a three-pronged balancing act. For the plaintiff to win in an invasion of privacy for monitoring email or surveillance in general, there has to be a showing that the plaintiff has a reasonable expectation of privacy. A reasonable expectation of privacy. The second issue, and by the way, this is the same test for invasion of privacy in drug testing, is you look at the need of the defendant to surveil, to monitor the email. And we've talked about the benefits of employers monitoring employee email, right? The evils that the employee may conduct himself. Sexual harassment. It's easy to sexual harassment through email as opposed to a face-to-face conversation. The stealing of trade secrets, the infringement on another's copyright, right? The wasting of time during the workday, that sort of thing. The visiting of porn sites in the office. All of these are examples of the needs of the employer to monitor the email. And then the third, you look at the level of intrusion. How intrusive is it? All right, so reading the emails of someone from the server when they're supposed to, they shouldn't be putting them on the company email system if they don't want them read, and at least certainly not during the company work hours. All right, now compare that with a drug testing, a blood test that was done for drug test purposes, in which an employer is not only looking for drug and alcohol, they're also looking for medical conditions. Pregnancy, for example. Right? Illnesses and so forth that would be determined by a blood test. You see how the level of intrusion is much higher in that situation? And so there's a balancing of those three. That's all of common law torts. The next lecture will be on product liability.